this lecture on John Locke. Friends, this is not a lecture. This is, is a reading of, John Locke. And this is a third reading on John Locke. Previously, last two readings, we talked about J.S. Mackland and second, Jeremy Walden's writings on John Locke. And today, friends, we are moving on to a third reading. As you already know, this is a reading of George Klosko. It's a very good writing. It's a compulsory read. You should come across George Klosko for the reason that he, touches almost every aspects of John Locke's political philosophy. So Klosko titled this reading into John Locke and liberal political theory. And this is taken from George Klosko's book, History of Political Theory, an Introduction, volume 2. So friends, Klosko says that John Locke's second treatise of government defends the rights of individual against unjust political authority. So he claims, Klosko claims that Locke's second treatise of government defends the rights of individual against unjust political authority. So the claim is that John Locke's writings coincide with the Glorious Revolution and the removal of James II, which we have already come across in the readings of J.S. Mackland and Jeremy Walden in the previous lectures. So Klosko says that, friends, Locke's language indicates that he wrote his second treatise on government to justify revolution, a successful revolution against Stuart monarchy. So second treatise, in a sense, or ever since it was written, was used by groups or societies to justify revolutions, popular revolutions against unjust political authorities, including the American Revolution. In a sense, that's why John Locke was considered to be the intellectual godfather of American Revolution. You might have read it in the J.S. Mackland or Jeremy Walden writings. So, friends, as we have already come across, the first treatise is a detailed refutation of what Sir Robert Filmer talked about divine right of kings, that we already discussed. And the second treatise begins where the first treatise leaves off, or where the first treatise ends, the second treatise begins, and systematically answers some of the specific questions being raised by Sir Robert Filmer in his book Patriarcha. And Klosko says Filmer need not be taken less serious as a student of political philosophy. You should not underestimate Filmer in the sense that what is Locke today in the academic discussions of political philosophy, that is just because of Filmer. So Robert Filmer, and Locke's response to Robert Filmer created the image Locke now possesses in the academic discussions of political philosophy associated with contractual traditions. So, friends, in this reading of John Locke, chapter 3, Liberal Political Theory, in the book of George Klosko, you should read between page number 114 to page number 119, 114 to 119, with the subtitle Locke's Life and the Intellectual Background. So this section will give you an elaborate portrait of the intellectual situation, the intellectual atmosphere which created the philosopher John Locke. So Klosko says in his writing, and in our reading also, you will see that Locke lived in a time of revolution in England. That we know it was somehow justified, glorious revolution. And this revolution shaped his thoughts. Like other readings, Mugland and Jeremy Walden, Klosko also talks extensively about Locke's connection with Shaftesbury, that we have discussed in the previous reading of J.S. Mugland, that he was connected to Shaftesbury. In the crisis atmosphere of the period in which he lived, Shaftesbury fled to Holland in 1682 because England was going through some political turmoil. And in 1682, Shaftesbury fled to Holland, where he died. And Locke too fled to Holland in 1683, fearing a persecution or some kind of suppression in England. Until James had been removed from power, Locke remained in Holland. That's why, friends, we have come across in the previous readings that even though Locke started writing all his books a couple of years ago, he was able to publish these books only after the Glorious Revolution. That's why, he didn't acknowledge its authorship. So Locke published two other very important books in 1689, along with the treatise. First one, an essay concerning human understanding, and a letter concerning toleration. These are very important books, from the perspective of a political philosophy student, that Locke's political theory recognizes his close connections with the revolutionary political organizations opposed to the Stuart monarchy. So he was opposed to the Stuart monarchy. Locke was opposed to the Stuart monarchy, and he was, in a sense, supporting the cause of Whigs, and he was opposed to the Tory, which we have discussed in the previous lectures. Not lectures, the previous readings. So, friends, that's why, as a student of political philosophy, when you read the two treatises of government, you need not to read it as a pure academic exercise. You need not to read it as a pure academic exercise. Why? Because Locke wrote two treatises of civil government not as a pure academic interest, not as a pure academic exercise. Rather, this writing coincided with ground realities in which England was passing through. So his writings coincide with some political movements that happened during his time. So this is not a pure academic exercise, rather it has something to do with the practical or ground realities of the time. So you have to read it that way, not as a pure academic exercise. So Locke's concern, which we can see that he addressed in that book, is related to the specific circumstances in which he lived. So he was answering many of the realities of the time and was finding solutions to the problems that England faced. So he was an opponent of royal absolutism that we have come across in the previous readings. And Locke attempted to counter the most important. Locke attempted to counter, or what may be called destroy. In a sense, we can say destroy the most important theoretical defense of royal absolutism. And royal absolutism was defended by Sir Robert Filmer through his book Patriarcha. And friends, you know that in the medieval period, which we have come across during our readings on St. Augustine and St. Thomas Aquinas, that the main argument of the medieval theological scholars was that they always favored absolute royal power, that the power of the king was derived from God. I hope you remember during our readings of St. Thomas Aquinas, 14th century, and the 5th century, St. Augustine, that these people, scholars, theological scholars, defended royal absolutism in the name of God. And you see, throughout the medieval period, we can see that royal power was granted to king directly by the God. And this was what the theologians of the day defended. And according to Sir Robert Filmer, therefore, since God has given the kings their power, the king has unchecked and unbridled power. You cannot question the power of the king. And Sir Robert Filmer was a major, major defense of this kind of an argument. And once again, sorry, friends, audible? Am I audible?
Yes, sir.
Yes, sir.
Okay. Friends, you see, Filmer in his book Patriarcha, Sir Robert Filmer in his book Patriarcha takes strong biblical support, particularly from the book of Genesis. And Sir Robert Filmer has taken lot of proof for his argument that king has derived his power directly from the God. And for example, you can see in Patriarcha, he referred to St. Paul's epistles to the Romans. St. Paul's epistles to the Romans, which says like this: let every person be subject to the governing authorities, for there is no authority except from God, and those that exist have been instituted by God. Romans 13:1. You can see in the Bible, St. Paul's epistles to the Romans. These sentences you can pick, and Sir Robert Filmer has taken and sourced this epistle of St. Paul to the Romans for providing proof to his argument. That's why, Sir Robert Filmer took up most of his defense from biblical sources and argued that king has his right directly from God. So arguments of this type in political science lexicon, we used to say divine right of kings. And we say that state originated through divine right of kings. This is a sort of argument existed during the medieval period, which you might have come across during undergraduate days from the political theory and political thought classes. But friends, in 17th century, this sort of an argument is not a winning argument, right? This sort of argument was not a winning argument because it's not convincing that king derived his power directly from the god. This is, a stupid argument, right? So in 17th century, one of the most dominant opponents of divine right of kings or royal absolutism was social contract theories. That's why, social contract theory got credibility as a sound opponent of royal absolutism or the kind of arguments put forward by Sir Robert Filmer. Social contract theories in general argued political power is not held unconditionally. Political power is always conditional. That is the core of social contract theories. People are originally free. They argued, we are all free by our nature. So political power derives from people. We create the political power. And we give that power to a ruler. And we grant him the consent. And why we granted our political power to the ruler? It is just because we want to make sure that we enjoy certain things and that ruler ensure that. And particularly, the point is that we give that political power to the ruler to protect us from foreign enemies. We want to protect the ruler. We want the ruler to protect us from enemies and also from one another and to promote public welfare. This is the idea of what may be called, social contract theories. This brings the notion of social contract theories. And obviously, friends, when I say this to you, this brief statement that medieval absolutism and divine right of kings, which was defended by Sir Robert Filmer, which was later challenged by social contract theories, in which they argued that people are free, they are born free, and they enjoy certain rights, and rulers' power are limited. And this sort of arguments are very simplistic, in a sense, very simplistic and very commonsensical. But friends, this is not that simple when we go deep into the crux of the matter. For example, Filmer's main argument depends on identifying the power of fathers and kings. For example, we can understand how complex it is, though we would feel that it is so simplistic an argument. Filmer, for example, identify the power of the kings and the fathers. Like many medieval thinkers, Filmer argues that Bible is the source of the right of the kings. But rather than concentrating on the fact that God has placed rulers on their thrones, instead of, concentrating on the fact that God has placed the rulers on their thrones, Filmer, in his book Patriarcha, focused on the facts of creation. He referred to the book of Genesis. And he was saying that Adam got his power directly from the God. That's why Filmer was saying Adam was not only the first father, but also the first king. And subsequent generations of his descendants are not born free, but in subjection to Adam. That Adam's sons, and their sons, that way, are subjected to Adam and his successors. That's why the power of the Father is very important, and the Father derived power directly from God alone. That is Filmer's argument. That's why he called patriarcha. Power comes through father line, not through mother line, or not through the evil line. So contract theorists argue that people are originally free. We are all free. We are born free. And we are free of government. When we were born, there were no governments. Until we voluntarily surrender to a public authority, we are free. But Filmer always countered this argument. Filmer always challenged this social contract argument. Filmer was saying that people are not born free. People are not born free, but we are born into families. We are born into families. And see, just look the way in which their arguments, counter arguments, moving forward. Sorry. So people are not born free, according to Sir Robert Filmer, but they are born into families. They are born into families. That's why all of us who are born into a family are naturally subject to the authority of the father first, not mother. We are all subject to the authority of their fathers. This is the argument of Sir Robert Filmer. And in his first treatise, Locke describes Filmer's position as consisting of two claims. So Locke is proposing his theory by attacking Sir Robert Filmer's position that Filmer's arguments consist of two main important. You have got two core arguments. What are them? First, all government is absolute. That is first argument of Filmer. Second, Filmer argues no man is free. This is the crux of the arguments of patriarcha of Sir Robert Filmer. And Filmer holds that paternal authority, not maternal, authority is paternal, the father line, not mother line. Paternal authority has always been absolute. That we are all subject to the authority of father in our families. Just like that, king is our father, not only our ruler. So we are all, part of that bigger family. So as a father, the king has command over all our authorities, all our rights. So this relationship of subordination is natural. People are not equal. That Sir Robert Filmer says. As a son or daughter are obviously below the authority of the father, just like that, people are not equal in nature. Sir Robert Filmer argues. So the reader of Filmer, if you read Patriarcha of Robert Filmer, you will note that the power of the father or the king extends beyond political domain. Sir Robert Filmer extends the power of the father or the king beyond the political realm, and he extended this to the realm of property also. That means in the absolute power of the ruler, Filmer argues, ruler also possesses right to ownership. That means all the property in the nature belongs to the ruler, not to us. The king owns all as he rules all. That is what Filmer says. And Sir Robert Filmer, in a sense, argues political power is also a form of property. Political power is also a form of property. So question of this ownership are therefore important to Filmer as well as to Locke. So look friends, in 17th century, when Sir Robert Filmer wrote this book, this got, some kind of, support from the absolute monarchies of Europe, because absolute monarchy will, support this idea, Filmer. And of course, they persecute John Locke, because John Locke was directly opposed to this idea by writing the book, Two Treatises of Civil Government. That's why, ownership is important both to Filmer as well as to Locke. And from a contemporary perspective, friends, when we look at Sir Robert Filmer and his Patriarcha from the value system of our days, this argument is so much absurd, right? This argument is so much absurd. This argument is so much, stupid. It is unconvincing. It is unconvincing. So, many of his premises, that is Sir Robert Filmer's arguments, the premises of his arguments are poorly supported, as well as based on misunderstandings of Bible. That is what John Locke argues in his first treatise. A good example for proving the fact that Sir Robert Filmer misquoted Bible. Sir Robert Filmer, am I audible, friends?
Sir.
Okay. So some internet connectivity. Clear, right? So a good example which John Locke used in his first treatise in order to support his own argument that Sir Robert Filmer was misquoting Bible in order to support his argument was this. He used the biblical injunction that honor thy father to support the need to submit to the paternal power. This is what Locke refers to what Sir Robert Filmer said in Patriarcha, that power belongs to the father and father got power directly from the God. Honor thy father. But Locke says this is misquoted. This is misquoted. And he says Filmer reading of Bible is poor and he misquoted sentences and biblical passages is misquoted in the sense that it is not honor thy father. Rather, he was saying that honor thy father and thy mother. You honor your father as well as your mother. That is what Bible says. But, Filmer selectively used sentence passages from Bible to support his argument. And in his first treatise of civil government, John Locke was referring to all those misquoted facts, directly showing that this is not honor thy father, this is like this, honor thy father and mother. The passage does not pertain to the monarchical power of the father, but what was due in common to both father and mother. So you should give due to your mother as well as your father. That is what Bible says. So throughout the first treatise, Locke argues against all the central arguments of Sir Robert Filmer. This is how the philosopher called Sir John Locke developed. This is how John Locke evolved as a very powerful intellectual force of the 17th century and in 18th century by attacking the royal absolutism of Sir Robert Filmer presented in his book Patriarcha. And Locke recounts four main points in his first treatise, which was an attack of Sir Robert Filmer. What was that? The first point, Adam was not given power by God. First point. Second, even if Adam had been granted the power, his heirs did not have the right to it. Second point. Third, that even if his heirs did have such a right, there are no clear rules of succession. There are no rules of succession. There is no mention of those things in Bible. There are no clear rules of succession according to which a rightful heirs can be named after the death of the father. And fourth, even if there were such rules, that is succession rules, it is impossible to identify Adam's actual heirs because the population increased. Because of the great length of the time that has passed, there are so many people who were born on this earth and died. And among them, we are not in a position to identify whom God's original power has been granted. It's very difficult to identify. This way, Locke, argues his, attack on, moves his attack on Sir Robert Filmer. Thus, friends, Patriarcha was probably written in 1630s. It was published until 1680s. So it was, published 50 years later. Long after Sir Robert Filmer has been died in 1653. So it was published posthumously. But friends, even though this book was a support to royal absolutism and divine right of kings, and today with today's value system, when we look at Sir Robert Filmer's arguments in Patriarcha, we will feel that this is so unconvincing. But friends, it doesn't, no matter what he said, his Filmer was seriously taken by 17th century and 18th century writers. That's why Locke felt to respond to Filmer. That's why he wrote the first treatise, an attack against Sir Robert Filmer. And the 18th century and 17th century writers had seriously taken Sir Robert Filmer's arguments. It is evident from the fact that even Book 1, Chapter 2 of Rousseau, Social Contract Theory, his Social Contract, Rousseau in Chapter 2 of his Book 1 makes references to Sir Robert Filmer. See, even Rousseau has referred to Sir Robert Filmer. That signifies the importance that Sir Robert Filmer's arguments had, which had great influence of those days. So friends, having criticized, this is the intellectual background in which John Locke, the writer, the philosopher, has been evolved. This is the background, that is attack on Sir Robert Filmer. This is why the philosopher has been evolved. And from in this Klosko's writings, you will see that from page number 119 to 123, Klosko was talking about state of nature and law of nature, which we have extensively talked in our previous readings of J.S. Mackland and Jeremy Walton. And Klosko also approached this idea of state of nature and law of nature from a very different angle. And you see, Klosko argues that, like Hobbes, Locke uses social contract as a weapon. He uses social contract as a weapon. He begins by posting a situation. He begins by posting a situation without political authority. He begins his second treatise by placing a situation, a social situation without political authority. And in social contract writing, this situation is called state of nature. And this approach was significant because it calls our attention to the problems that the government must solve. When we begin an argument with a situation in which there was no government, we will be later convinced that yes, we need some type of a political authority to solve that problem. So, it's a tricky argument. That's why right from all my readings, I am trying to tell you that social contract is a tricky type of argument. The specific form of government one endorses will depend on the problems in the state of nature. That the type of government that you are going to propose is dependent upon the type of problem you are going to confront in the state of nature. Because the problems that government must solve depend on the theorist conception of human nature, right? So how the government will solve the problem will depend upon how the social contract theorist propose human nature. So it's a tricky business. Social contract is a tricky business. So in order to be convincing, of course, a contract argument must give a persuasive answer to two different questions. A social contract argument tries to give answer to two questions. First one, the first concerns the choice of government in the state of nature. What type of a government that we should choose in a state of nature? That, for example, friends, if you are a social contract theorist and you will justify limited monarchy, for example, you will justify limited monarchy, for example, for the reason that people in the state of nature was quarrelsome and it was a situation of war of all against all. So people are quarrelsome, people are inward looking, people are not, loving creature, people are not social creatures. If you argue like this, you will in the end argue that we need a very strong government, just like what Machiavelli said, so that a powerful government can crush out all these what may be called asocial behavior of man. It's a tricky argument, right? This is what all the social contract theorists are doing. If a theorist wishes to justify a specific form of government, if you're a social contract theorist, and if you want to justify that I would like to prefer this type of a government, you will argue by looking backwards to a particular account of state of nature. So, for instance, if you wish to justify a communist society, suppose if you are a social contract theorist and you want to argue that yes, it is better to have a communist society, then you would argue that that people in the state of nature, right? You will argue, you look back and you will argue that yes, look, people in the state of nature would be a staunch communist. Why? Because they have faced great injustices in the distribution of wealth, so that they were looking future about a situation in which there was equal distribution of wealth. So this way you can make arguments. That's why I told you it's a tricky business. Or if you wish to justify a feminist state, you will argue that people in the state of nature were suffering by gender discrimination, so they want to get out of it and to establish a feminist state in which both the genders get justice. Or if you wish to justify an absolute state, you argue that people in the state of nature were asocial, inward looking. So in order to get out of this, you have to propose an absolute state, just like Thomas Hobbes did. So in many respects, we are all Lockeans, friends. Our conception of the nature, human nature, and the purpose of political authority are, closely connected. And the specific political form Locke wished to create was limited government. If you read page number 119 to 123, you will see that Locke preferred limited government. For example, in order to justify a form of government that is unlimited, you just refer to Thomas Hobbes' Leviathan. Hobbes presented before us a state of nature that is so ridden with conflict that people would willingly surrender virtually all their rights in exchange of security, because in the state of nature there were no security. There were a warlike situation in which future was uncertain. That's why all of us are ready to willing to surrender all of our right to a political authority, and that political authority will give us all our right back by providing a security. That was Hobbes' position. And when it comes to Locke, Locke doesn't go the Hobbes line. He constructed a state of nature with less conflict than the one envisioned by Hobbes in his Leviathan. Locke presented the state of nature that is different from a state of war. So far from being a horrific condition, that is what Hobbes proposed, Locke's natural condition is described in his own words. Hobbes' state of nature is described in his own words as a state of peace, goodwill, and mutual assistance and preservation. You refer to page 9 of second treatise. Page 9, not page 9, page 19 of second treatise. Klosko referred to that sentence in his reading. So in opposition to Filmer, Locke argues that we are in the state of nature naturally free. Friends, we were all born free. Unlike Filmer, Locke argues. And Filmer argued that we are not born free. We are born to a family, and where there is a father, and we are under him. And father got power directly from the God. The evidence is Bible, the book of Genesis. Adam was given power directly by the God. This is Filmer argues. But John Locke argues, friends, we are all born free. And you see, although you are born to a family, of course, we are all born to a family. Just like what Filmer said in Patriarcha. We are all born to a family. And you must live for a time being under the authority of your parents, particularly your father. And also your mother. You should live under the authority of your parents. This is the only temporary condition, according to Locke, that is to be distinguished from political subjection. The only time in our life we are put into some kind of subjection, but it should be distinguished from political subjection. This is not a political subjection, but Filmer says this is also a political subjection because there is no difference between a ruler and the father. But Locke, attacked Filmer here. Man is naturally free. He exists in the state of nature with a liberty rather than license. Page number 6 of second treatise, if you refer. Klosko referred this sentence in his reading. As a reasoning creature, friends, you are all a reasoning creature. You have got a natural reason. Man is born free, and man is born also under the law of nature. We are also born under a law of nature. There is a law of nature, which sets limits to our relationship to other people and to ourselves. So there is a law of nature that governs us. This law of nature depends on God. This is God-given, laws, and God is the author of this law and the creator of man. Men do not belong to themselves but to God. That we do not belong to ourselves but to God. So friends, because of this sort of argument, we will feel that John Locke was somehow a medieval thinker. That he resembles with what St. Augustine said in 5th century AD and what St. Thomas Aquinas has said in the 14th century AD. That this here, that when in his conception of state of nature, law of nature, Locke somehow resembles a medieval backward-looking writer, that he was saying that laws are given by God. But friends, the way in which he presented law of nature is a bit different from St. Thomas Aquinas and St. Augustine. Like many theorists of the medieval world, Locke argues that natural law is promulgated to man through his reason and directs him to his proper interest. Page number 57 of second treatise of civil government. Klosko referred this. And Hobbes and Locke are the first prominent political philosophers in the Western world to speak extensively about a natural right theory. They were the first to propose natural rights, that you have studied human rights, right? When you studied human rights, friends, we came to know that even before political authority was created, people who are born on earth will have some kind of right. That no matter if you go to USA, no matter if you go to London, no matter if you go to South Africa, as a human being in all these territories, Even though you are not a national there, you have some kind of rights which will be protected even by a nation state other than yours. Why? Because this writer, that the idea of human rights was evolved directly from the writings of these people, Hobbes and Locke, that they say that by our very nature, by our very birth, that you are going to enjoy certain rights which will be enjoyed by all human beings born on this earth just because of the fact that you are born. All states are supposed to protect that. So friends, this idea of right begins from the tradition called natural rights. And this tradition was initiated by these writers, Locke and Hobbes. God is believed to be the author of the law of nature and also generally the enforcer of the law of nature. And Locke's view of natural law is traditional in this most respect, because here Locke goes back to the medieval writers. We saw in the last chapter that that's readings of Hobbes, in the not last chapter, the readings of Hobbes, that Hobbes uses the language of traditional natural law. But in his own view, he departs from this traditional natural law tradition in fundamental respects. And in a sense, Hobbes' natural law theory subvert traditional doctrines of natural law. But when it comes to Locke, he was not like that. He was purely a traditional thinker in terms of natural law theory. That is, in his essay on concerning human understanding, you can see that, and also Klosko refers in his reading that Locke argues human mind contains no innate ideas, that nature hasn't created any innate ideas. Nature hasn't written anything in our mind. We didn't enjoy any innate ideas. Everything that we know is just because of our senses, that we touch, we see, we smell. See friends, just we have 5 senses, and through these 5 senses we make all knowledge, we make all ideas. So all our knowledge is empirical, and our knowledge is just because we experience it. There is no universal law. There are no proof that there are no universally moral truth. All truth are relative to our, depending upon our experience. This is the crux of the state of nature and law of nature in John Locke. You read page number 119 to 123, and you read, friends, page number 123 to 127. Page number 123 to 127 under the subtitle "Natural Rights and Right to Punish." In this section, you will see what John Locke says about natural rights and how you are punished when you break the rights of other people, when you violate the rights of other people. Locke never gives a detailed account of what is meant by natural rights. Friends, he never explicitly talks about what is natural rights, and Klosko agrees that, and in his own interpretation of Locke's writings, particularly 2 treatises of civil government, you can see that Klosko makes it clear that Klosko will tell you that nowhere in his writings Locke refers directly to what is meant by natural rights, but we can glean it from, we can gather this idea from by interpretation in second treatise. For instance, in the section following his discussion of natural law, he easily shift towards the language of rights by saying that, and that all men may be restrained from invading other people's rights and from doing hurt to one another. So this is a notion of right that we enjoy. Locke makes it clear. Page number 7 of second treatise. Klosko refer this. And rights, friends, rights are commonly understood through the metaphor of a protected space or territory. surrounding each individual, that we have a protected territory, an imaginary territory, within which you should be secure to pursue your own ends. That is called, rights. Rights is a normative notion, a metaphor that gives you a protected space. To say the space is protected indicate that it is protected from other parties, means both from the other individuals as well government, and government need not to interfere, other individuals need not to interfere. But this is a protected space. This is mine. It is not yours, and you have to protect. You have to respect that space. This is a notion of right. And of course, all the theorists distinguish rights from two angles. One is the natural rights, and the other one is legal rights. Some people argue that all the rights you have come from state. Some people argue that some rights are specific rights, and that is not granted by state, but this rights belongs to you just because you are a human. And this is rights from nature. The former, that is the natural rights tradition, that all people, by virtue of the fact that you are a human, you will enjoy rights. This is what social contractualists say. So it doesn't matter whether you are a Frenchman or an Indian or an English citizen or an American, or the enactment of some legal system, but because of the fact that you have certain human characteristics, you will enjoy certain rights. So natural rights, according to Locke, come from the fact that we are God's creature. We are God's creature, and we are created by God. So we have certain natural rights. Legal rights, on the other side, friends, this is we get it because we have a political authority, and that political authority is vested with the right to the authority to promulgate laws, and all our rights come from that promulgation of enactments or promulgation of rights, because of the fact that they enacted some laws. And for example, these kinds of rights are guaranteed in the Indian Constitution, fundamental rights, and all the rights that we enjoy comes not through Bible, or not through Quran, or not through Gita. All the rights that you enjoy because of the fact that you are a citizen of India is just because we have a constituent assembly which created a constitution, and the constituent assembly was created by the people, and the constituent assembly said that the constitution is we the people, and we the people has created a government, and government has enacted some laws, and that laws grant you certain rights, and the highest law is the constitution, and in the constitution you will get certain legal protection. That is called fundamental rights, and all the rights you enjoy directly come from the government, from the constitution, from the state. That is legal notion of right. That is not natural rights tradition. Natural rights are rights not through government but through nature. So in the US political system, you will see Bill of Rights, that they have incorporated certain rights to the citizen. Indian Constitution, there is rights, fundamental rights. These all the rights are because of the state laws. So friends, Locke does not plainly use any kind of the language of rights in his writings, but we can interpret that he uses the language of rights in his treatises as well as in other writings. For example, he makes notes of a person's uncontrollable liberty to dispose of his person or possessions. That you have all the right to dispose of your person or possession. That's your right. That's rights coming through your liberty. That's Locke says. Or Locke says, each person has naturally a right to freedom to his person, which no other man has a power over, but the free disposal of it lies in himself. This is, Klosko interprets by reading second treatise. This way we can interpret that Locke makes references to right. So Locke says that men in the state of nature are free to order their action. We are all in the state of nature free to order our action, dispose of our possessions and person as you think fit within the bounds of law of nature. So within the bounds of law of nature, we are all we are all free to order your action, dispose of your possessions, dispose of your person in a way that is fitting to yourself within the bounds of the state of the law of nature. Klosko refers to page number 4 of second treatise. But this is a pressing problem that, friends, if you are free in the state of nature, how you will subject to some government. It's a very pressing problem in John Locke. So we were all free in the state of nature. Then why do you go to a government? This is a very cunning question, a tricky question in John Locke. And friends, because it is precisely the absence of an effective enforcement mechanism. Precisely there was an absence of an effective enforcement mechanism in the state of nature. Men living together according to reason, that we were all living together according to reason in the state of nature, without a common superior on earth. We haven't a common superior on earth, with the authority to judge between them, is properly the state. That what is the role of the state? The role of the state is to judge between the claims of the individual. That's what we have also seen in the readings of Magland last day. So the state of nature is distinct from civil society. The state of nature is distinct from civil society. So Locke is going very specific about various concepts. There are so many keywords in Locke, just like we have seen in Thomas Hobbes. There are so many keywords, and he is proposing another keyword, that is civil society. The state of nature is distinct from civil society, and civil society and state of nature are different. Civil society is a condition in which there is a common judge between all of us. There is a common judge between all of us. And in the state of nature, there is no common judge. In the state of nature, there is a common judge, and we all have our own notions about what is our right in the state of nature, and we define our right according to the bounds of law of nature. And when we define our right within the confines of state of nature, of course our perspective of our own right may come in conflict with the perspective of a right of other persons. And when such conditions emerge, friends, there were some kind of inconvenience. That's why we created a civil society. And in the civil society, unlike state of nature, we will have a common judge amongst all of us. Clear, friends? Did you get the idea? So, the common judge was absent in the state of nature. But in civil society, we will have a common judge. And in the state of nature, we have seen that each of us is surrounded by a sphere of protected space that is called right. Clear? That is right. And all of us in the state of nature were surrounded by a sphere of protected right, within which you can pursue your own ends within that protected space. But what is to prevent other people from interfering in the protected space of each one of us? That all of us have a protected space in the state of nature, and we all respect that other people's protected space, but there will be some kind of confusion when we enter the protected space of other people, or when other people enter into the protected space of our own. That is called right. In such situation, there is no clue that what we should do. And Locke's solution to this problem is the strange doctrine. And Locke here proposes another keyword, that is strange doctrine. You refer to page number 13 of second treatise. Page number 13 of second treatise. He proposes a keyword, strange doctrine. What is it? Locke's solution to this problem, that you enter into the protected space of other person, or other person enter into the protected space of you, that in the state of nature, all men are enforcers of natural law. We are all enforcers of natural law because we enjoy this protected space that is called right within the bounds of natural law. That's why all of us are enforcers. All of us are enforcers of natural law. That's why we enjoy our right. This is called strange doctrine. This contention follows from the fact that people are in the state of nature are equal. All of us are friends. You are all equal in the state of nature. That is what Locke says in the second treatise. So in contrast to Sir Robert Filmer's Patriarcha, Locke argues against the relationships of natural subordination. That, in the state of nature, all of us are born equal. But Sir Robert Filmer never agree with that. No one have an exclusive right to enforce law of nature. You don't have any exclusive right. If you enjoy a right to enforce law of nature, I too enjoy, and they too enjoy, and all other people enjoy the same right to enforce law of nature. So all people have the power of enforcement. All people have the power of enforcement. This power gives each person the right to punish. This power gives each person the right to punish not only violation of natural law that directly concerns himself, but those that affect others as well. That's your power to enforce law of nature. Concern not only to the enforcement of law of nature in times of violation of it, not only related to you, but also related to other people. That's why, there are times you will transgress the law of nature. An offender may declare himself an enemy to all the men. An offender may declare himself an enemy to all the men. You refer to page number 8 of second treatise. Klosko refers this in his reading. So the need to preserve the law of nature from violations justifies the practice of punishment. That is, when there is, need for punishment of violators of natural law, we need some authority. That punishment is necessary in times of violation of natural law, that we have to bring perpetrator into account. Second, the right to do this is held by all the people. The right to do this, that the right to punish a violator of natural law is held by all the people. In addition, if some violations of natural law damages a specific individual, that particular individual has a right to compensation. And this right to compensation is held equally by all the people. That's why, friends, John Locke proposes his theory of natural right and natural right to punish. Friends, shall I wind up this lecture? Because we are running short of time, and there are some other areas in his reading that he talks about civil society in his Klosko's reading, and he also talks about government by consent, and Klosko also talks about right to property, and he also talks about when we should resist unjust authority, why revolution, and also page number 159 to 164, Locke and liberal political theory. So some other titles, keywords: civil society and government by consent, the notion of consent in Locke, right to property, and also resistance to unjust authority, and finally Locke and liberal political theory. These are some other keywords that you have to read. Friends, do you want me to continue this lecture next day, or will you read it? Friends, please, will you read it, or do you want me to continue this lecture tomorrow?
Continue, sir. Sir.
So do you want me to continue?
Huh?
You want me to continue next day?
ആ സാർ.
ആണോ? നിങ്ങൾ വായിക്കില്ല?
വായിക്കും സാറ് പറഞ്ഞ.
ആണോ? ഞാൻ വീട്ടിൽ ലെക്ചർ ചെയ്യണത് നാളെ. ഞാൻ വിചാരിച്ചു നാളെ അടുത്ത ലെക്ചറിലേക്ക് പോകണമെന്ന്. ഒരുപാട് സമയം പോയി. എന്താ വേണ്ട? നിങ്ങൾ എല്ലാവരും പറ. നിങ്ങൾ പൊതു തീരുമാനം
കണ്ടിന്യൂ ചെയ്യണം സാർ.
കണ്ടിന്യൂ ചെയ്യണം അല്ലേ?